In prior cases, the NDMB recommended maintenance of membership in cases where unions asked for union security. Such recommendations were uniformly accepted, but in this instance, there was a real danger of rejection. Therefore, when it became clear that the NDMB would again follow this policy in spite of bitter opposition from CIO members, a major crisis appeared imminent. Conferences of War Department and other government officials were called by the public members of the NDMB to discuss what to do in the event that the miners struck upon the rendering of such a decision. As a result, the War Department undertook the preparation of a plan to seize and operate the captive mines. Under the plan, responsibility was divided between a troop commander, Lieutenant General Robert Richardson, Jr., and Director of Operations, Colonel David McCoach, Jr., with final responsibility vested in neither one. General Richardson prepared an elaborate program that called for large numbers of combat troops, armed with tanks and heavy artillery, to be deployed to the mining areas to guard the persons, properties, and families of non-strikers and to serve as a threat to strikers. Colonel McCoach's plan was similarly elaborate, calling for the establishment of a Central War Department office in Pittsburgh with a director of operations and technical experts in mining, public and industrial relations, and fiscal matters. He also urged creation of regional offices with a similar director and group of technicians in each affected mining area, as well as the designation of a War Department representative to act as manager of the coal mines of each company. Specific nominees for nearly every one of the several hundred jobs listed were included. McCoach's plan contemplated only token seizure until the war. The department could determine to what extent the companies would make their managers and finances available to the government during the latter's period of control. The first step in the plan was a meeting with steel executives, where they would be asked to operate the properties for the government with their own funds. If they refused, direct operation with federal funds would result. Most of these federal funds, however, would in reality be supplied by the steel companies through payments to the government for any coal furnished from seized mines. The operating plan was ably conceived and well drawn insofar as its legal, fiscal, production, safety, public relations, and administrative aspects were concerned. It failed entirely, however, to deal with the crucial question of how the War Department would induce the miners to return to work if the mere fact of the government seizure did not do so. The dependence of the plan on expectations of an automatic and voluntary return to work pure as a result of a simple seizure and the division of responsibility contemplated led the labor section, OUSW, to take exception to its implementation. McCoach was convinced of the wisdom of the labor section's view, which gained further support when Lewis ordered a second walkout following the adverse decision of the NOMB and the failure of further negotiations. Lewis stated bluntly, "If the soldiers come, the mine workers will remain peacefully in their homes, conscious of the fact that bayonets in coal mines will not produce coal." The labor section emphasized that the problem was a psychological one, a problem of convincing the miners that they should return to work voluntarily. Seizure was a technique that should be exclusively directed toward that objective and patterned in every detail with that goal in mind. Before there was any need for resolving these basic differences in approach, or the need to put either to an actual test, President Roosevelt proposed arbitration, which was agreed to by both parties. The UNW called off its strike, and the crisis passed, both in 1943 and again in 1945. The War Department was confronted with the possible task of seizing coal mines on an industry-wide scale when it was doubtful whether the mere act of seizure would end strikes. In each instance, it undertook the preparation of an extensive plan, as formidable in character as that developed for the captive coal dispute. The framers of the 1943 plan sought to remedy the primary defect of the 1941 program is its failure to deal with the question of how to get the men back to work. The plan called for the induction into the armed forces, either on a voluntary basis or under the Selective Training and Service Act, of all workers in idled coal mines, and further provided for the commissioning in the Army of supervisory personnel. The mines were to become military installations, with officers in charge and enlisted men mining coal. While many recognized that such an experiment might be necessary as a last resort, it was severely criticized by the Labor Branch, Industrial Personnel Division, Headquarters, Army Service Forces, as being unrealistic, unworkable, and probably illegal. While perfect in its every military detail, it overlooked the all-important factor of human nature. Very fortunately, it was Secretary of the Interior, Harold L. Ickes, rather than Secretary of War Stimson, who was ordered to take over the mines. After many very crucial days, during which time only nominal possession of the mine properties was assumed, Ickes restored production. However, the return to work did not result from the fact of seizure as such, but because Lewis had obtained what he wanted through direct negotiations with Ickes. Negotiations that not only bypassed the National War Labor Board, NWLB, but also ignored established government labor policies. The coal crisis of 1945 produced a third War Department plan. This time, plans were developed in close cooperation with the Labor Branch. The doubtful features of the 1943 plan were eliminated or modified, and an entirely different approach was adopted based upon the then extensive War Department experience in individual plant seizures. This new approach was spelled out in various memoranda for Magister General Glenn E. Edgerton, the proposed War Department representative, and in proposed instructions for labor officers. Considerable thought was given to the possibility of others sought to amend the Sabotage Act to include strikes within its scope, and still others proposed compulsory arbitration of disputes. There were also renewed pleas for the enactment of a specific law authorizing plant seizures. Some law seemed inevitable, but before Congress acted, the end of the mine strike, the outbreak of war, and other events completely changed the picture, diverting attention away from attempts to secure labor legislation for almost 18 months. During the 9 months that followed the captive coal crisis, there were no further War Department seizures, but other important developments took place, materially affecting the character of all subsequent takeovers. First, the American entrance into the war changed public attitudes towards strikes and most labor groups. Almost immediately, the number and the average, the size and duration of strikes decreased sharply, and the strikes that did occur were clearly contrary to the great weight of public opinion. While the fact of war became less and less of a restraining influence as time went on, particularly by 1945, one could almost always depend upon the underlying patriotism of the great majority of workers, and capitalize significantly on this fact in any plant seizure. Both public and labor opinion usually supported a return to work under government auspices. Second, in early December 1941, President Roosevelt convened a conference of management and labor leaders for the purpose of developing the machinery and policies to resolve industrial disputes without resort to force. Out of this conference came the No Strike Pledge, by which management and labor agreed to avoid lockouts or strikes for the duration. The parties further agreed to submit all disputes not resolved by direct negotiations or through conciliation to a tripartite board equally representative of management, labor, and the public, whose decisions should be accepted by the parties as final. There was nothing legally binding about this pledge, nor did the decisions of the newly created NWLB have any legal force and effect. However, the recommendations of this conference set a certain moral tone for management-labor relations for the duration, and the commitments of the conferees represented covenants that could not be lightly disregarded, whereas previously strikes had often been condoned, and in some instances actively supported by some organized labor leaders, and whereas the NDMB's recommendations were occasionally flouted by important segments of industry and labor. The representative leaders of both groups had now solemnly declared themselves as squarely behind the new policy. General support of this policy by national leaders, labor, and industry in later years proved a tremendous asset in cases where an irresponsible local labor leader or some uncooperative management official deviated from the pledge to such an extent that government seizure was necessary. Moreover, the establishment of an agency whose decisions were accepted as final and binding by all persons, if the voluntary no strike, no lockout pledge was to work, but which were nevertheless not enforceable through court process, eventually resulted in the actual, though never admitted, use of plant seizures, not merely as an instrument for maintaining critical war production, but also for the purpose of upholding this pledge and the proposition upon which it was dependent, that the NWLB decisions must be accepted in every case. Lacking judicial remedy in cases where the attitudes of labor or management threaten the cornerstones of the government's labor policy, the NWLB and the president occasionally invoked plant seizure to secure what in effect constituted specific performance of an NWLB decision in a case where the threat to war production, while perhaps present, was extremely remote or indirect. The advent of war could not indefinitely postpone a violent eruption of industrial disputes, seriously threatening the war effort. Controversies, muted by the patriotic fervor that followed Pearl Harbor, gradually came to the surface, and by June 1942, there was again a scattering of strikes affecting important procurement. The War and Navy departments became concerned lest this rash of disorders result in a whole series of plant seizures to settle disputes that the government should be able to be handled by other means. This concern developed at about the same time as a feeling frequently expressed in editorial columns and also shared by many government officials that it was improper to use the same remedy in every case, that is, plant seizures, irrespective of whether labor or management was at fault. It was asked why management should have its business confiscated when labor was in the wrong, or why labor should suffer when management was at fault. While much of this public feeling was based upon a wholly erroneous conception of the purpose and character of plant seizures. The feeling that seizures punished the innocent was widely held, and it seemed desirable to change this perception. Both these developments were largely the product of experiences with the seizures of the S.A. Woods Machine Company, South Boston, Massachusetts, and the General Cable Corporation, Bayonne, New Jersey, in August 1942, cases that revealed other matters deserving of attention, namely serious, though unintended, lack of coordination between the NWLB and the procurement agencies. In the General Cable case, for example, President Roosevelt, at the NWLB's insistence, signed an executive order directing Navy seizure not only without submitting the order to the Navy Department, but also without the latter's knowledge. Moreover, it was later generally agreed that the order to seize was ill-timed and probably unwarranted, and that proper staff work among the agencies involved would have prevented it. Likewise, the S.A. Woods order never received department clearance, and in both cases, the orders had been abominably drafted. In light of all the foregoing circumstances, and faced with the imminent possibility of a takeover of the Vernon, California plant of Alcoa, the War and Navy departments asked for a conference with the NWLB's public members to review the use of plant seizures as a technique and to agree upon standard procedures. The resultant conference, attended by Secretary of the Navy Knox, Assistant Secretary of War McCloy, Colonel Edward S. Greenbaum, and Wayne Morse, the acting NWLB chairman, and later a senator from the state of Oregon, discussed a general procedure that might be jointly recommended to the President by their three agencies for use in all cases. There was little difficulty in reaching such an agreement, and on 22 August 1942, a memorandum was transmitted to Judge Samuel I. Rosenman, who forwarded it to President Roosevelt. This memorandum made the following recommendations. 1. In cases where an employer defies a decision of the War Labor Board, the President will direct the Army or the Navy to take possession of the plant and cause it to be operated in a manner that effectuates the purpose of the decision of the WLB. In cases where employees strike or otherwise interfere with production in defiance of decision of the WLB, the President will notify the strikers that unless they return to work at once, they will lose their occupational deferments under the Selective Service Law and will also be ineligible for employment in war industries. Whether the President will also direct the Army or the Navy to take possession of the plant and cause it to be operated will be dependent upon the circumstances in each case. There was substantial conflict within the War Department on the second point, but it expressed a view reiterated on many occasions by Undersecretary Patterson that the best way to deal with strikes in war plants was to induct the striking workers into the Army and not undertaking plant seizure. President Roosevelt did not agree. He was unwilling to issue a work or fight order in the absence of a seizure, but he was ready, in conjunction with a seizure caused by labor defiance, not only to clearly place the blame where it belonged, but also to invoke the Selective Training and Service Act and to threaten the blacklisting of any person who failed to return to work. Following this advice during the Alcoa strike, the original conferees devoted themselves to the preparation of an executive order and an accompanying statement that would conform to President Roosevelt's wishes. The end of the strike made the particular order and statement academic, but Rosenman asked that they be processed in the normal fashion through the Bureau of the Budget and the Department of Justice for approval as a model for use in subsequent cases. However, it was more than a year before the Army or Navy was involved in another seizure, and during the interim, these papers were nearly forgotten. They were later resurrected, although the strike of the United Mine Workers of America, UNW, against the steel company owners of the captive coal mines in the fall of 1941 never actually required a War Department seizure. Planning for such an eventuality did take place. The first phase of this strike began in October 1941 when the steel companies, after months of negotiations, refused to grant the closed-shop demand of 101 Mr. L. Lewis, the president of the UMW. The stoppage had the immediate effect of seriously reducing bituminous coal supplies at steel mills, and this in turn threatened steel output, perhaps the most critical of all war programs at that time. There was a short respite late in October when, at President Roosevelt's request and with a promise of expeditious consideration of the case by the National Defense Mediation Board, NDMB, Lewis suspended the strike and the NDMB took the matter under consideration. Point.